Notice that the economic justification for trademarks is different from those for patents and copyrights. Unlike patents and copyrights, the economics of trademarks does not concern innovation, temporary monopoly, or constrained dissemination. Consequently, we cannot make the same economic argument for limiting the duration of the property rights in trademarks as we did in the case of patents and copyrights. Limits on the duration of patents and copyrights were justified as attempts to minimize the social costs of monopoly and tracing. However, trademarks encourage competition and do not impose tracing costs. Superscript 20, which reads, see for general information, William Landis and Richard A. Posner, Trademark Law and Economic Perspective, 30 J. Law and Econ 265, 1987. Returning to the text, perhaps this is why trademarks can last forever until abandoned. In this respect, trademarks are like property rights in land and unlike other forms of intellectual property. The question of breadth in trademarks has an interesting twist. Nothing is more settled in the law of trademarks than the proposition that generic product names cannot be trademarks. For example, no producer of cameras may register the word camera as a trademark. To allow such a trademark would enable its owner to sue every camera manufacturer that advertised its product by use of the word camera. If generic product names can be trademarks, then the law of trademarks would create monopoly power rather than facilitating competition. Sometimes, however, a competitive product succeeds so far that its trademark becomes a generic name. For example, people today speaking of Xeroxing when they mean photocopying, or they speak of Scotch tape when they mean cellophane tape, or they speak of a Hoover when they mean a vacuum cleaner. When this situation arises, the trademark owner must protect the trademark by suing rivals who use the generic name to describe their products. Otherwise, the producer loses its property right in the generic name. This sort of thing happened to the Sterling Drug Company in 1921, and that year a U.S. federal district court determined that Sterling's trademark name for acetylsalicylic acid, aspirin, had become the common word for any brand of that drug, not just Sterling's. After this ruling, all producers of acetylsalicylic acid could use the term aspirin to describe their product. Bayer has managed to prevent this erosion of its trade name aspirin in Mexico and Canada, where no company but Bayer may describe its acetylsalicylic acid as aspirin. Superscript 23. The Bayer Company of Germany had discovered acetylsalicylic acid in the late 1890s. The U.S. government seized the trademark aspirin during World War I and sold the right to use that trade name to the Sterling Drug Company in 1918. Interestingly, Bayer purchased Sterling in 1994. Returning to the text. To learn how manufacturers of very successful products protect their trademarks, read the box on Coke on page 134.